Good evening and welcome to the 23rd finals of the Wabash College Moot Court competition. It's an event that's co-sponsored every year between the Rhetoric Department and the Indianapolis Association of Wabash Men. I'm Todd McDormand. I'm a professor in the Rhetoric Department and an associate dean at the college, and I help coordinate the competition. This year we had another spirited competition featuring a lot of enthused students, alumni and faculty who all contributed to the competition in a number of ways. The alumni and faculty who participated as judges were impressed with the preparation and skill of the student advocates in undertaking this voluntary, non-credit bearing activity. For volunteering, they had the responsibility and privilege of reading a complex legal problem, making an argument under intense scrutiny, and doing so early on a Saturday morning. It was quite a deal. From the original participants on Saturday, 12 advanced to the semifinal round last night, and before you have our 4 finalists for this evening's arguments. Before introducing the student competitors, I'd like to thank the students, alumni, staff, and faculty who participated in the competition. I particularly like to acknowledge Scott Himsel, John Pachter, Matt Griffith, Rick Pitts, and Seamus Boyce for their dedication to this program year after year. I'd also like to thank staff including Mindy Mills, Philip Marriott, Kitty Rutledge, alumni and parent relations, public affairs, campus services, and Bon Appetit. We have a lot of partners in this competition who make it possible every year, and we really appreciate it. I'll now introduce the finalists, after which Professor Himsel will introduce our final round panel. We'll then hear the argument, the judges will confer, announce a decision, and we have a reception in Littell Lobby. Tonight, representing the petitioners, that's the Dumont Church of Fredonia, and advocating on behalf of a religious organization that objects to its denial of participation in a grants program that would have funded resurfacing of a playground on church property, are Jacob Ream and Benjamin Wade. Jacob Ream is a junior from Farmersburg, Indiana. Jacob lives in Wolcott, and he is a political science and philosophy double major and an economics minor. His campus activities include Model UN, College Democrats, Parliamentary Union, and the Pre-Law Society. After Wabash, Jacob plans to attend law school. Tonight, he will represent the petitioners and will be making the free exercise argument. Joining Jacob is Benjamin Wade. Benjamin is a senior political science major and history minor from Clayton, Indiana. He's a member of Phi Gamma Delta. His campus activities include Student Senate, Model UN, the Bachelor, Pre-Law Society, and he's a writing center consultant. After Wabash, Ben plans to attend law school as well. Ben will be representing the petitioners and be making the equal protection argument. Please extend congratulations to Jacob and Benjamin. Representing the respondents, that's the state of Fredonia, who is arguing to affirm the lower court's decision upholding Fredonia's rejection of Dumont's application, are Walker Hedgepath and Colin Bell, kind of hidden behind me there. Walker is a sophomore from Munster, Indiana. Walker lives in Martindale, and he is a history major and an Asian studies minor. Walker's activities include the Glee Club, APO, International Students Association, Parliamentary Union, and he's a democracy fellow with the Wabash Democracy and Public Discourse Initiative. After Wabash, he plans to attend graduate school in history. Tonight, Walker will represent the respondents and will be making the free exercise argument. Joining Walker is Colin Bell. Colin is a senior from Richmond, Indiana. He is a political science major and he is a Spanish minor. His campus activities include being a member of the golf team, a peer career advisor for career services. He's the president of Sons of Wabash, and he's the president of Phi Delta Theta. After Wabash, Colin plans to pursue a career in law enforcement. Colin will represent the respondents and will be making the equal protection argument. Please congratulate Walker and Colin. At this time, Professor Himsel will introduce tonight's panel.
Thank you, Todd. I'm Scott Himsel from the class of '85, and I'm very happy to introduce our distinguished judges. Serving as our Chief Justice this evening is the Honorable James M. Carr, United States bankruptcy judge in the Southern District of Indiana in Indianapolis. Judge Carr was an English major at IU and received his law degree from IU Maurer School of Law, magna cum laude in 1975. For 38 years, he practiced law at the firm of Baker & Daniels, now Faegre Baker Daniels, handling a wide variety of bankruptcy and commercial litigation matters and receiving the coveted distinction of being named a Fellow of the American College of Bankruptcy. His community service is widespread as an adjunct professor at Maurer School of Law, WFYI Public Radio, coaching youth in many activities, including the Law Explorer post at the law firm. Judge Carr, thanks for leading us this evening.
Thank you for inviting me.
We're also very pleased to welcome Austin Parrish, Dean, and James H. Rudy, Professor of Law at Indiana University Maurer School of Law in Bloomington. Dean Parrish graduated from the University of Washington and earned his law degree at Columbia University in New York City. Dean Parrish is a widely published scholar in both domestic and transnational law, including the role that national courts play in solving global challenges. He's also published books and articles directed toward helping lawyers write more effectively and helping students succeed in law school. He's also taken a leadership role, not just at Maurer, but nationally, in making legal education more practical and effective. Dean Parrish, thank you for joining us tonight as well.
Thank you for having me.
Also joining our panel is the Honorable Kurt Eisgruber, Wabash class of '87, and a judge of the Marion County Superior Court since January of 2009. Judge Eisgruber was active while at Wabash at Sigma Chi, football, and baseball. He majored in history and minored in German. He served our country in the United States Marine Corps in Operation Desert Storm. He attended IU McKinney Law School in Indianapolis and worked as a prosecutor and in private practice before taking the bench. Since taking the bench, he has presided over approximately 100 major felony trials, including over 25 murder trials. Judge Eisgruber, thanks for coming home to Wabash. Thanks. Our final judge, Mr. Steve Bowen, represents the faculty tonight. Mr. Bowen graduated from Wabash in 1968. He was active in his fraternity, Phi Gamma Delta, and graduated with Phi Beta Kappa honors. Mr. Bowen then attended law school at the University of Chicago. In his private practice, Mr. Bowen specialized in the federal income taxation of business transactions, including especially mergers and acquisitions, at the firm of Latham & Watkins, from which he is now retired. Mr. Bowen serves as chairman of the Board of Trustees at Wabash, and he's currently teaching an ethics course here at Wabash as an adjunct professor. Mr. Bowen, welcome back too. Thank you.
All right. Petitioner appellant, are you ready to proceed? Respondent appellees, you ready to proceed? Petitioner appellant, please proceed.
Your Honors, and may it please the Court, my name is Jacob Ream. I represent the petitioners in this appeal, Dumont Church of Fredonia. We contend in this case that that the state of Fredonia violated the free exercise clause of the First Amendment by restricting our church's access to a grant which would have allowed us to retire the playground at a church-owned child care facility. It is well established by Supreme Court precedent that the First Amendment free exercise clause cannot be infringed upon on a religious basis. If we weren't a church, we would have gotten the money to rehabilitate our playground with the recycled scrap tires. The state of Fredonia even admits that they didn't grant it to us
Counsel,
precisely.
how does it impact the free exercise? I don't get the nexus between a school playground and how it impacts your ability to exercise your faith in the church.
Yes, Your Honor. The way it impacts our exercise of faith is because the discrimination in this case occurs precisely because we are a religion. It would force our members and our daycare to choose between a religious affiliation and this publicly available funds.
But are you saying that it's the state's obligation to subsidize your church?
No, Your Honor.
As a matter of free exercise, they have to pay for your operations?
No, not at all, Your Honor. This is a purely secular good. It's retiring a playground. It serves no religious purpose. It only serves to increase the safety of the children who play on our playground.
Do we have to overturn the Locke decision in order for you to win?
No, I don't think so, Your Honor. I think that this case, unlike the Locke case, is a purely secular good, which would allow our children to be more safe.
Yeah, but isn't Locke a stronger case? Locke was, this is more problematic, right? This is a direct funding to a church, while Locke was indirect, and yet it was directly focused on penalties for somebody who's wanting to do theology. That seems to be much more sort of pernicious on free exercise because it's specifically preventing somebody from studying the subject of their choice.
Yes, Your Honor, it is more pernicious in its free exercise infringement. However, that would have been a direct subsidization of a church's faith. This is not. As I've said before, it was a purely secular good, retiring the playground.
I'm still not clear on what the infringement on free exercise is. Seems like somebody can go to church whether you have this playground or not. There's no interference with religious practice that I can see.
Yes, Your Honor. However, the members of our church would be unable to have this publicly accessible good while remaining members of a religious organization. And that's where the free exercise infringement comes in. They're being forced, in this case, to choose between being religious and having scrap tires in their playground.
Yeah, but that's exactly what happened in Locke. And the court said there was no free exercise, and arguably in Locke, there was a much greater infringement on the exercise of religion because he couldn't study theology. How do you square those two?
Well, Your Honor, in that case, and unlike in this case, there was a direct subsidization of a religious good, whereas in this case, the only good is secular.
But that's not true. It was an indirect subsidy because in the Locke case, the payment was going to the individual, not to the church. Mm-hmm. This is arguably even worse in establishment jurisprudence because you're directly funding the church.
Well, it is different in that you would not be directly funding the church. You're directly funding an ancillary.
But money is
part of the
fungible. It's for an ancillary purpose, but the money can be moved.
Well, yes, Your Honor. However, in that case, funding a scholarship for a theology student would have gone to the specific purpose of assisting an establishment of religion, where in this case, it only assists in the establishment of a safer playground, which I believe is the largest difference.
I take it that your parishioners at your church have been going to the daycare center long before this program ever came up.
Yes, Your Honor.
They didn't get a grant. Still not clear on how this is interfering with anybody's religious rights, with the exercise, somebody's actual exercise of religion. Sure, they don't get a grant. That's too bad. But nothing has really changed as far as any of them are concerned. You applied for a grant and didn't get it. So what's the infringement on religious exercise?
Well, the infringement, Your Honor, comes in because we would have gotten it. We would have received the grant had we not been a religious group. And in this case, that's where the discrimination occurs. If we had not been a religious group,
well, discrimination, but what is the infringement of religious exercise?
Because our parishioners are being forced to choose between being religious and having a safer playground, Your Honor.
But in the Locke versus Davy case, the scholarship applicant had to choose between either studying theology or getting the scholarship. Isn't it the same dilemma that the Supreme Court upheld in Locke versus Davy?
No, Your Honor, it is not the same dilemma. This good, in our case, is a purely secular one and would not go to subsidizing the religious practice of the church in any way, where in that case, the study of theology would have directly subsidized a faith.
What authority does a state have to enact a law that doesn't go all the way up to the Establishment Clause but protects them from Establishment Clause type claims? What I mean, can you address what play in the joints have to allow this legislature to protect itself from Establishment Clause claims by being perceived that it's supporting a church?
Well, I think that Locke here is an excellent case to instruct us, Your Honor. I think that in that case, there was a direct subsidization of a religious good, whereas in this case, as in any case that the court should overturn, there is no direct subsidization of a religious good, and that's what we're arguing today.
You know, you keep saying that, but in Locke, the fact that somebody studies theology doesn't mean that they're going to be a minister, doesn't mean that they're So I don't get the direct subsidization of a religious purpose. I don't see that distinction that you're making between your case and the Locke case.
Well, Your Honor, I think that when you're studying a religion, the purpose would be to gain more knowledge about that religion, and that would be a direct subsidization of faith, whether they go on to promulgate that faith or not. Whereas in this case, no religious good is accomplished by retiring a playground and making children safer.
Are you arguing this case is closer to the Widmar decision?
I think so, Your Honor. I think this is closer to Widmar in the sense that in this case we have no there is no way that our good can be construed as a religious one. There is no anti-establishment. There is no establishment case on the part of the state. They would not be subsidizing an establishment of religion, unlike in any other case, unlike the Jones case. So,
Am I correct, though, that the state does not need to prove that there would have been an Establishment Clause violation? In fact, they have quite a bit of leeway to protect themselves from Establishment Clause claims. So even if it may be true that this would not create an Establishment Clause violation because it's not a direct subsidy directly going to the church, certainly the state has leeway to create a statute that provides some cushion between what the Constitution prohibits from establishment and what it's willing to do. In this case, saying we don't want to go even close to it, and so unless we're really clear that this isn't money that's fungibly going to the church through some other route, we're not going to fund it. Isn't that exactly what our jurisprudence allows the states to do?
well, Your Honor, the jurisprudence allows the states broad leeway in direct subsidization of religion. You are correct, and as it should. The First Amendment is very clear on this, that any government should not subsidize religion directly. However, in this case, there is no anti-establishment case for the state. The monies in no way would assist our religion. They would only assist in the safety of children.
Counselor, in the decision below, Judge Driftwood thought that this was resolved by a plain text analysis. How do you react to that? The plain text of the free exercise clause.
Well, Your Honor, I think that would be a bit short-sighted, Your Honor. I think that in this case, to look at the plain text is to ignore a great deal of jurisprudence that exists outside of that. I think you'd be ignoring precedent.
And what sort of cases do you think support your position?
Well, I think the Department of Employment v. Smith and McDaniel v. Patty both support our case pretty well. I think in that...
Can you expand on the McDaniel versus Patty, how you think it supports your case?
Yes, I think that McDaniel v. Patty, ministers were prevented from being representatives to a constitutional convention. And the court overturned that ruling, just as it should in this case, because there was a direct infringement on the ability of a person to hold both a public office and a religious office at the same time. Whereas in this case... Don't
you see a distinction between holding a public office and getting your playground covered by tires? Those seem to be different sort of rights and privileges as a citizen that are at stake.
Well, yes, Your Honor, they are different rights and privileges of a citizen, but they are rights and privileges, both the same. Just as...
Who has a right to a playground?
Excuse me, Your Honor.
I'm sorry, who has a right to a playground?
Those children who attend the Gummo Learning Center, Your Honor, which is a wholly owned subsidy of the church. So I think that another case that we could look at here is Tarasco v. Watkins. It invalidates religious classification. Many other cases, in fact, invalidate religious classifications in free exercise. It's important here to consider that when we're talking about the free exercise of the church, we're, as I've said before, not talking about a religious good that's going to be subsidized by this money. What we are talking about is that children will be safer and that our playground would be more comfortable. It has been the case...
The church should be entitled to this money?
Well, as it happens, we are entitled to this money, Your Honor. We would have been awarded it had we not been a religious group. The state has said this. There's no argument over that fact. So I think it's...
If a local community, a city decides to have a competition to build a new art structure outside its courthouse, and they say we're going to have anybody submit, but it can't be a religious cross. And for you, that's a free exercise violation, right?
No, Your Honor. I don't think it is.
Why not? What's the distinction there from prohibiting funding of a religious paying the installation of a religious art design in front of a courthouse.
No, well,
why is that not? Well, in this case, it is.
Using public money to subsidize religious art is much different than using public money to subsidize the safety of children, Your Honor, and I think that's fairly clear. I think that if we were to subsidize a piece of public art on I see my time is up, Your Honor. May I conclude?
Go ahead and complete your thought.
Sure. By having a religious iconography in a piece of art that's funded by the public, you would be directly subsidizing an establishment of religion, whereas in this case, you are directly subsidizing the safety of children. And with that, we respectfully request that you overturn the lower court's decision. Thank you for your
very
time.
much. Please
Good evening.
proceed, Mr. Wade.
Good evening, Your Honors. May it please the Court, my name is Benjamin Wade, and I represent the Dumont Church of Fredonia, the petitioner in this appeal. At this time, I'd like to request 2 minutes for rebuttal.
Certainly.
While my co-arguer addressed the state's policy First Amendment violation, I will argue that this policy also violates the Equal Protection Clause of the 14th Amendment.
Do you have to win on the argument that Mr. Ream made for your equal protection argument to prevail?
We do not, Your Honor. However, because I firmly believe that we do win under his argument, it simply adds to my component of the argument. First, because this policy hostilely discriminates a suspect class's fundamental right, the court must apply the strict scrutiny standard rather than the rational basis test that the state would prefer that we use, or the court use. And under that strict scrutiny standard, the policy fails, as the court has previously held that the states can...
How do you view religion as a suspect class to justify strict scrutiny?
Actually, the courts have ruled in that favor. The court's application of strict scrutiny comes from footnote 4 of the Caroline Products case, where it says, when the court enters into a review of statutes discriminated at particular religious, national, or racial minorities, or against discrete and insular minorities, in cases like City of New Orleans v. Dukes, which said a law or regulation triggers strict scrutiny under the Equal Protection Clause if it, quote, is drawn upon inherently suspect distinctions such as religion.
Mr. Wade, in this case, it says that we have a rule where we have excluded all religions. Is all religions a suspect category? Here, all religions are excluded from the competition. Somebody graded them for some reason, but all were excluded. Is all religions a suspect classification?
Yes, it is, Your Honor, because they are...
Is there a case that holds that?
The broader example that goes to this is Metro Broad Incorporated versus the FCC, which says at the heart of the Equal Protection Clause, the idea that you're treating all individuals equally, not based on components of racial, religious, sexual, or national class. So again, the fact that the state is...
I understand that, but in terms of cases actually involving issues of religion, is the class of all religions a suspect category?
In the case that my co-counsel actually referred to, Widmar v. Vincent,
yes.
The court used strict scrutiny because the university's policy excluded all religions in that case.
Let me ask you this question. You agree with me that there are Establishment Clause cases, right, where there's discrimination against religion by virtue of the Establishment Clause that does not trigger a free exercise violation. You would agree with that?
Yes, Your Honor.
If I agree with your interpretation of equal protection, doesn't that wipe out all my Establishment Clause cases? Because by definition, in each one of those cases, I've discriminated against religion by preventing the establishment of religion, and I don't have a free exercise clause claim, and so I've got to meet strict scrutiny. And the court has never applied strict scrutiny in that way after they've determined there's no Establishment Clause violation, right?
Yes, Your Honor. But in this case, there is a free exercise of religion prohibition. By doing
if I disagree, yes, but if I disagree with your co-counsel, so I find there is no free exercise, you're left with your equal protection claim. And what I'm concerned was if I apply strict scrutiny, doesn't that call into doubt all my Establishment Clause jurisprudence going back for 100 years? Because in each one of those cases, I would have had an equal protection claim because I'm treating religion differently than I'm treating non-religion.
The difference for this case, Your Honor, is that the Establishment Clause, the Establishment Clause concern that the state has put forward as their compelling interest in this case is not nearly as big of a problem as they would have the court believe. Again, the connection between...
Let's say I agree with you, though, and I'm not worried about this case, and I'm worried about future cases. Under what circumstances am I not going to have a successful equal protection claim in any Establishment Clause type case? So anytime a state decides that it is going to discriminate against religion because it cannot do a direct funding of a church, under your theory of equal protection, doesn't that trigger an equal protection strict scrutiny analysis?
A case that would do that would be similar to Locke v. Davey, where the court held that there was no fundamental right violated, and then they used the rational basis test. But again, comparing Locke v. Davey to this case, because it is a suspect class, all religions, getting back to Justice Bowen's point, because it is the class of all religions and a fundamental right is violated, this does trigger a strict scrutiny standard. And under that strict scrutiny standard, again...
Why didn't it trigger it in Locke?
Because the court found that a fundamental right hadn't been violated. The court found that that Davey's right to practice religion wasn't violated in that case. Because a fundamental right wasn't violated...
But clearly in that case, so I understand there wasn't a fundamental right violation of the Free Exercise Clause, but in that case there clearly was discrimination against a religious group. The scholarship on its face said, you can use this so long as you're not using it for studying theology. Why doesn't that trigger an equal protection claim? And it seems to me that you have to overturn Locke in order to succeed in your method, because implicit in Locke is the idea that equal protection has to have a rational basis review by demand of the exercise of the Free Exercise Clause and the Establishment Clause.
Could you rephrase your question, Your Honor? I'm
Sorry, and I apologize. It seems to me that if you either have to urge us to overturn Locke, because Locke specifically says in an equal protection claim you apply rational basis review. It may be true that a fundamental right wasn't implicated in Locke, but that hurts you because in your analysis you're saying there's a fundamental right implicated whenever you discriminate against religion. It's clear in Locke they were discriminating against religion, and the court said you determine whether there's a free exercise problem, and if there's not a free exercise problem and there's not an Establishment Clause problem, you're in rational basis review. And so what I'm interested in is, do you think that we need to overturn Locke in order to move to your position? And if not, how do you reconcile the two?
Again, I think it's because in this particular case you have both of those components. You have the state's interest in anti-establishment is not as great a concern in this case as it is in Locke v. Davey, because again, directly giving money to theology students going to grad school is a much more narrow, direct path to practicing religion than the secular giving of a grant to repaving a playground.
So let's say I agree with you. Wouldn't that still mean that Locke should have applied strict scrutiny to the equal protection claim? You got a bigger problem, both on establishment and free exercise. You've got clear discrimination against religion. Shouldn't that trigger the strict scrutiny standard under your theory?
It should have, Your Honor. But again, moving forward from this case, the strict scrutiny standard applies to this case, again, because it does involve both sides. And moving to the strict scrutiny test, this policy cannot pass because it doesn't even make it out of the gate. It trips and falls on the compelling interest part. Again, the Widmar v. Vincent...
For your purpose, Counselor, for equal protection, does it matter to you that it's a question of status versus actual practice, where the state is making a discrimination based on your status as a church versus what you're doing?
It does, Your Honor. It is because this is a blanket status-based discrimination against all religions, not just Catholics, not just Muslims, but all religions. And that is why they're not getting into different practices or beliefs. This is all religion. And that's why it triggers the equal protection, because it encompasses all religion.
Now, tell me again now, is there a case that treats all religions, that category, all religions, as a suspect classification?
Again, moving to Widmar v. Vincent, they use strict scrutiny for all religious groups, all religious organizations on this particular campus.
That was a freedom of speech case, wasn't it? Student groups?
It was, Your Honor.
It was discriminating among student groups.
It was, but the type of group that they were discriminating against makes it applicable in this case, because like I just said, it brings in the religious component to it. They're treating all religious groups in this discriminatory matter in Widmar v. Vincent and in this case.
How about McDaniel versus Patty? Does that help you? Is that an all religion discriminated group?
Seeing as my time has expired, may I respond? Yes, it does, and that actually helps us even more so, because in McDaniel v. Patty, there was a coercive effect of making ministers choose between, you choose between your job as a minister, or you choose between this public good of...
And you would say that was status. It was because of the status that they were being discriminated.
Yes, Your Honor. The status of being a minister or a man of the cloth affiliated with the church. And with that, Your Honor, we humbly request that you reverse the lower court's decision.
Thank you, Mr. Wade. All right. Respondent appellant, appellee. Please proceed.
May it please the court, my name is Walker Hedgepath, and I am representing the state of Fredonia in this appeal. The state of Fredonia believes that its Department of Natural Resources has not violated the Free Exercise Clause of the First Amendment for three distinctive reasons. First, its action is upheld on the free exercise coercion test. Second, there's no precedent for subsidization under the Free Exercise Clause. And thirdly, the constitutional provision in question, Article 1, Section 7, is part of the play in the joints between the Free Exercise Clause and the Establishment Clause.
Well, you say there's no subsidization element, but wouldn't the church have a free exercise gripe if you didn't pave their streets so people couldn't get to their church?
Indeed, Your Honor, but that's actually that's of a different nature.
How so?
Because, Your Honor, in the instances of such services as streets or fire and police protection, those are generally available public benefits.
Well, isn't this a generally available public benefit? Everybody else had a shot at this tire program, did they not?
Indeed, it is not, Your Honor, because only 13% of the applicants that applied for this grant actually got it.
But everybody could apply. Nobody was shut out at the door.
Yes, Your
And
Honor.
in fact, the church scored higher than all but 4 other applicants, did they not? So why isn't this a generally available benefit?
Your Honor, this pertains, the reason why the church was excluded from the grant application process is because the state of Fredonia is concerned about being seen as funding or subsidizing religion. And that in and of itself goes against Article 1, Section 7 of the Fredonia State Constitution.
That failed in McDaniel versus Patty, didn't it, that argument?
In the case of McDaniel versus Patty, Your Honor, that case was fundamentally different because in that particular case, Tennessee prevented all religious clergy whatsoever from being eligible to run for election to the state constitutional convention.
All right, I understand that, but you're preventing all churches from participating in your program that everybody else gets to participate in.
But, Your Honor, with the case of McDaniel versus Patty, that was a case of political significance because that was a state constitutional convention. This is simply a grant that the state has for improving playgrounds.
Do you agree that the core of our jurisprudence in this area is that the government can neither favor nor disfavor religion, and then must treat religion and non-religion equally?
That is the case, Your Honor.
If that's true, then how do you justify this process? Certainly, you have death by 1,000 cuts if through all the different ways that you could fund different groups, if religious groups are always excluded from that, including things that have nothing to do with religion, such as playgrounds for kids?
Indeed, Your Honor, there's an answer to this question within Locke v. Davie, because within Locke v. Davie, the Washington State Constitution had a provision that was nearly exactly the same as Fredonia's. In particular, Article 1, Section 11 of the Washington State Constitution that was at hand in that case was that no money shall ever be taken from the public treasury, directly or indirectly, in aid of any church, section, or denomination of religion. And the Supreme Court upheld that this was part of the play.
It's a secular issue. It's building a playground, which they rightfully applied for and won a grant for, and then were excluded. I view that as distinct from the Locke decision in that this is wholly secular. It's not a religious component. It's for a playground, nothing more.
It is true, Your Honor, yes, that the playground is purported to be secular, but again, this goes back to the important distinction, though, that the state of Fredonia raises, that the state cannot be seen as giving money to religious organizations, even for secular ends such as this, because of concerns over the establishment.
You wouldn't argue, you're not actually arguing that if they did decide to fund this, that there would be an establishment clause violation, right? That clearly is not the case here, right?
That is the case. That is indeed the case.
So if we don't have an establishment clause issue, what we're really trying to do is suggest where they are in the play in the joints, how close they are to the free exercise clause, and how much they are close to the establishment clause.
Yes, Your Honor.
So if we don't have an establishment clause problem, shouldn't we be very concerned about states that are overreaching well beyond what the establishment clause requires in such a way that seems to systemically penalize churches for acting for things that have nothing to do with the religious aspects?
Your Honor, the Supreme Court, however, has upheld such similar restrictions upon religion in the past. For example, in the case of Ling versus Northwest Indian Cemetery Protective Association, the U.S. government built a road through land that was considered sacred to the local Native Americans, and in that case, the court upheld the government's action on the basis that the Native Americans could still practice their religion whether or not a road was present through the sacred lands. So it is within the history of this court to uphold such restrictions. And additionally, an example of where the court has taken action against...
Does it matter to you where Gummo Daycare is located? If it were off premises, would that change your opinion, sir?
It would not change my opinion, sir, Your Honor, because of the basis that it is still owned by the Dumont Church. And a case in which...
Is that the primary factor? Let's say it were off-site and it taught religious classes, they did prayers, but they weren't associated with the church. Would that change your opinion?
It would not change the state's opinion, Your Honor, because it is still inherently tied to a religious organization. And a contrary case that shows an action where a state government did go too far and the Supreme Court sided with religion is in the example of the Church of the Lukimi Babalu I versus the city of Halia, in which the city government passed an ordinance specifically banning the sacrifice of animals, which was a sacred rite of that religion. And in that particular case, the court sided with the religious group in recognizing that there are limits to what governments can do in terms of imposing restrictions upon religion. So, moving on to address the fact that there is no subsidization precedent under the Free Exercise Clause. James Madison wrote in the Memorial and Remonstrances of 1785, religion both existed not only without the support of human laws, but in spite of every opposition from them. So it is the basic principle of the Free Exercise Clause and of the Constitution that it is not the duty of the government to specifically subsidize religions.
But Madison was just on the other side of this. I mean, it was Jefferson who had your side of the argument with regard to keeping subsidization out to avoid establishment. Isn't that right? Historically, wasn't it Jefferson versus Madison on this issue? And
it is true, Your Honor. Yes, it was between Jefferson versus Madison.
But whose side are you on now, Madison or Jefferson?
Well, I'm on the side of Jefferson on this particular issue when it comes to involvement with religion, because of the evolution of positions over time. But additionally, in Camerano versus In Camerano versus the United States, the court upheld this basic principle in that it rejected the argument that First Amendment rights are somehow not fully realized unless they are subsidized by the state.
Counselor, in the Smith case, the court said government cannot impose special disabilities based on religious status.
Yes, Your Honor.
Isn't that what you're doing?
No, Your Honor, because all the precedent that exists that opposing counsel has presented is actually amongst religious denominations. And this case is different in that it's pertaining to basically promoting the state's interest and not being seen as biased towards any particular
but
religion.
Don't we have the opposite problem here? That the establishment case law seems pretty clear that you can't disfavor religion, right, as it compares
Yes,
to
Your Honor.
non-religion. And by doing this, separate and apart from the funding, the mere statement that we have a law that says religion cannot be supported in any way, even for something that has nothing to do with religion, aren't you disabling and disfavoring religion as compared to non-religion? That over time, non-religious practices will prosper more so than religious practices. And isn't that exactly what the framers were trying to prevent? That government couldn't have a dog in the fight. It couldn't be supporting it or dissupporting it. And here, over time, you play this out in a large range of different things, you're going to downplay the incentives for people to create churches because they're not going to get all these other benefits that everybody else in the world gets.
Your Honor, Your Honor, with respect, however, this is not a generally available public benefit. And actually, as it pertains to specifically the free exercise concern that opposing counsel has presented, the Church of Dumont existed well before this grant, and it already had a playground, and it existed during the application process as well as afterwards. So
if they had enough money to fund everybody that applied, but for this, then there would be a violation?
Could you rephrase the question, Your Honor?
So the Chief Justice had asked you as to why this wasn't a general available program, and you responded, I believe, that it wasn't because only a small percentage was funded.
Yes, Your Honor.
And then you argued again right now that it's not a general benefit.
Yes, Your Honor.
So what I'm asking is if 100% of all the applications were funded, but for those from the church, then do we have a violation because it's a generally available program?
Yes, Your Honor, you would in that case, because then funding is directly guaranteed to all organizations that apply whatsoever. But that is contrary to the nature of this program because the state does not have unlimited funds, and so accordingly it can only pick the top 14 out of the 45. So, in combination, as an illustration of limitations that the state may impose, we have, for example, the case of Harris v. McRae, which illustrates, for example, the right to have an abortion established in Roe v. Wade. The state has no obligation to, for example, provide access for financially indigent women to have access to that abortion, and the way in which that matters to this case as well is that in that particular instance there is a legitimate constitutional right to an abortion, but the court found that the state isn't compelled to provide monetary support.
Get back to your argument on the state constitution of Fredonia.
Yes, Your Honor.
And clearly we're in the loose play of the joints, or
Yes, Your Honor.
in the joints with that. But the second clause, or the last clause of that constitutional provision includes that religion cannot be discriminated against.
Yes,
Is
Your Honor.
that not what's happening here? The state's not taking a neutral position. They're taking a position of discrimination against a church, a religion.
It is not, Your Honor, because in fact this is the state's primary way of preserving its neutrality towards all religious groups together. May I complete my answer to the question, Your Honor?
Right ahead.
But basically, it is the view of the state that by starting to grant money towards certain religions in selective applications, that this may lead to trouble down the road between competition between religious groups, and the state being seen as favoring the groups that won such selective competitions. And with respect to the court, I believe I respectfully request that the court affirm the lower court's decision.
Thank you. Mr. Bell? Please proceed.
May it please the court. My name is Colin Bell, and I, along with my co-counsel, represent the state of Fredonia, the respondents in this appeal. The issue at hand is if the state's exclusion of religious groups is a violation of the Equal Protection Clause of the 14th Amendment. We contend that it does not. I'll begin with finding the difference between strict scrutiny and rational basis.
Let me ask you this, Mr. Bell, because I'm really completely up in the air. How does this case exist in a world where Locke v. Davies exists alongside McDaniel v. Patty? Can you reconcile those two cases in your case? Do we have to overrule one of those cases? Do we have to change our precedent?
Your Honor, in the case of McDaniel v. Patty, the people of the gospel were barred from being delegates to the state constitutional convention. In that case, there was a coercive force being applied. You either choose your religion or your job, or be a delegate for your state.
And here you either have to choose to not be in the entire program or spin off your school to a secular holding. Isn't that the same kind of choice that Dumont's being faced with?
Your Honor, I would say it's a different choice. I would say in the case of McDaniel v. Patty, it is a larger scale public good. It would show political powerlessness if you were not able to be a delegate for your national constitutional convention. In this case, it is rubbering a playground, which, as the Dumont Church contends, it is a secular playground. So in this case, we look at Locke v. Davie, where a student was barred from studying theology, barred from getting a scholarship to study theology on the grounds that the state did not want to show favoritism to a religion. In this case, it's very similar. In this instance, the state of Fredonia is trying not to show...
Why should we use the strict scrutiny standard as opposed to the rational relationship standard?
I'm sorry, I understand why...
Why should we not use strict scrutiny as opposed to rational basis?
Your Honor, to classify as strict scrutiny, there has to be a history of discrimination and to show political powerlessness. In this instance, Dumont Church does not pass either of those. When you look at all religious groups, any time the court has used strict scrutiny for religion, it has been denomination specified.
Let me ask you this specific question. If I enact a law that says, I'll do two examples. Anybody who practices the Muslim faith has to come in and be fingerprinted. Rational basis review?
No, Your Honor.
Okay, so now I say anybody who practices any religion, if you're not secular, we don't trust you. We're worried about religious fanaticism. You've got to come in and be fingerprinted. Rational basis review?
Your Honor, I would contend in that instance that it would probably more likely fall under the suspect classification. For instance, because it is not close to being an establishment issue, and it would have to pass a compelling interest of why the state would want to do that.
So why, though? In my second example, I've just said all religions. Anybody of any religious faith has to come in, arguably not a substantial burden on the free exercise rights, but clearly unequal treatment. I've enacted a law specifically designed to discriminate against people who believe religious beliefs rather than non-religious beliefs. So why is that different in this case?
Your Honor, in that case, it would be different because when you look at the instance of your hypothetical question that all religions would have to come in to be fingerprinted. In the case we have today, where all religions are excluded from a scholarship to resurface a playground, it's a difference in what is actually being done to those religious groups.
Yeah, but why is that different for equal protection analysis? Either I have a suspect class or I don't. If you say all religions is not a suspect class, rational basis, which means under my hypo, you should be able to do it. And the rational basis review allows the government. So under your theory, I should be able to enact that law if I'm a state.
But, Your Honor, for the strict scrutiny to be applied, it doesn't only have to be a suspect class. It could be a violation of fundamental right. So what we have today in this case with Dumont, we do not have a fundamental right violation, and we do not have a suspect class violation. So in the example you gave, it may not go under the suspect class, but it also could be contended under the fundamental right violation. So what we have today is we must look at whether or not the state of Fredonia...
Can I just push you on that? Outside of free exercise claims, how do you have a fundamental religious claim that's not a suspect classification claim?
Your Honor, I would state in that aspect it was whether or not it would be considered under that suspect class. So under the First Amendment, when you have the free exercise clause, that would be your fundamental right. That would be your right to freedom of religion, where you get to choose and practice your religion. The government cannot impede on that. So in that aspect, it may not be a suspect class, as we've seen where the court uses it for only denominations. But in that instance, it could be the fundamental right of you being unable to practice that religion.
Would you agree with me under equal protection analysis if I enacted a law that said all African American citizens must come in and be fingerprinted? That clearly a violation and strict scrutiny analysis, right?
Yes, Your Honor.
Assuming I have no fundamental right violation because there's only an incidental burden to the practice of religion, so I require you to send something. Why shouldn't I? I know you're saying the doctrine, but why shouldn't we treat that as a suspect class? It seems to me that my hypo, where you treat all religions differently from non-religion, is exactly the type of thing that the founders were most concerned about, and where you'd want to have an equal protection claim on suspect classifications.
Your Honor, why we should not contend all religious groups as suspect class is because of the political powerlessness question. After the court handed down the Smith decision, all religious groups were pretty upset, and in that they rallied together and they got with Congress, and Congress passed RFRA. After the Supreme Court ruled that that was unconstitutional and Congress overstepped its bounds, the religious groups re-rallied and then passed RLUIPA. In that aspect, it's showing you the political power that all religious groups have when they're discriminated against, or in their contention they're discriminated against. So in order to classify as a suspect class, there has to be that political powerlessness aspect to it, which would then, if they did have it, would go to strict scrutiny. But in this case, all religious groups don't classify in the suspect class. The court has ruled when they have used suspect class religion, it's been denomination versus denomination. If the state of Fredonia claimed that all Catholics were barred from this grant and every other religion would apply and could receive it, that would be a challenge that could pass under suspect class. But today, the state of Fredonia is not contending that one denomination cannot receive the grant. It's saying that all religious groups cannot receive that grant. Under the rationale is that they're trying to further separation of church and state. They're not trying to show favoritism, whether it is actual or perceived, towards one religion. It becomes a very big problem in this aspect when the state of Fredonia would let that grant be applied to a church, in this case Dumont, and the public perception could be that the government is now establishing an official religion.
Counselor, if we disagree with you and decide that it is a suspect class and that it's an issue of strict scrutiny, do you lose?
No, Your Honor. I say that even under strict scrutiny, the state of Fredonia will still pass.
And how so? How would you justify it under strict scrutiny?
Strict scrutiny requires a compelling legitimate interest and be narrowly tailored. In that instance that I just mentioned, the state of Fredonia is trying not to show favoritism towards a certain religion. That would be a compelling interest. Once you...
But it's not favoritism towards any one religion. It's all religions who are being barred from this program.
That is correct, Your Honor, but not all religions would receive the benefit of resurfacing the playground.
Anyone that applied for it and met the criteria would.
That is correct, Your Honor, but in that instance of a church receiving those benefits, it could be perceived that whichever church, in this instance that Dumont received those benefits, that the state of Fredonia is establishing Dumont's official religion as the religion.
That just sounds like a PR problem. That doesn't sound like...
Didn't the court below view that as a rational basis standard as opposed to...
I'm sorry, repeat, Your Honor.
I thought the court below characterized what you're describing as something that would meet the rational basis test.
Your Honor, I would say...
Chief Judge asked you for what would... If you need a compelling argument, are you able to make it?
That is correct, Your Honor. We say that the state would still pass the compelling legitimate interest because the state of Fredonia is trying to prohibit an establishment clause issue.
How would that be narrowly tailored?
By the all-inclusive of all religions. If, in fact, that Dumont contends that it's not narrowly tailored because it has all religions and needs to be specified, it gets into a sticky situation when the government specifies what classifies as a religion.
But here we're talking about a playground. Let's not lose sight of the fact that it's a playground that is to the benefit of children, all the children of the community. I don't see how a strict scrutiny standard would allow the government to narrowly tailor it. And here's for the public good in a certain sense. I think it could be argued. So aren't there other means rather than this means to tailor the interests of the state if a strict scrutiny standard were applied?
Your Honor, I would say no. I would say in this case that the state of Fredonia is applying the state constitution, Article 1, Section 7, that is enacted to try to prohibit a future problem where the state is put in a conundrum.
So let me make sure I understand, though. Clearly, there would be a compelling interest to take acts that would not violate the Establishment Clause. I get that. But what you're saying is, since we all agree there is no Establishment Clause problem here, that there's a compelling interest to do much more than what the Establishment Clause requires. How does that work? How does the state have a compelling interest to do something that the Constitution doesn't require, and which if they wanted to fund, they could? They didn't have to enact the constitutional provision.
Your Honor, I would say that this goes into play in the joints that was said in Locke v. Davey. And that,
yeah, but the play in the joints, the play in the joints gives you some space between the free exercise clause and the Establishment Clause, and that makes perfect sense. I'm not aware of any of our prior decisions that say that play in the joint gives you an automatic compelling government interest to bypass any strict scrutiny claim.
that is correct, Your Honor. But in this instance, the compelling interest is to set the precedent. The precedent that would be set forth if this court ruled that it would be okay to fund a church if it received the benefits is a problem that could set forth another Establishment Clause issue. What we're looking at today is...
How does funding a children's playground and something that's not... How does funding a children's playground impact an establishment issue at all, even close?
Well, Your Honor, money is fungible. A dollar saved by not having to spend on the playground is spent on religious practice.
So do you agree with me then that all the government's faith initiatives are all unconstitutional based on that theory? So we have all these faith-based initiatives, right, that are all funneling money into helping the homeless, soup kitchens, done by faith-based groups. Been doing it extensively under the Bush administration, somewhat extensively under the Obama administration. All unconstitutional under your theory of establishment, right?
Your Honor, my time has expired. May I answer your question?
Go right ahead.
I would say no, Your Honor. I would say in this case what we're looking at is whether or not the state of Fredonia has the constitutional right to try to not violate the Establishment Clause. In this instance, the state of Fredonia has applied the Article 1, Section 7 of their state constitution to avoid a possible enactment of a violation or establishment violation. So to answer your question, Your Honor, I would say no. With that, we respectfully request that this court affirm the lower court's decision. Thank you.
Thank you. Petitioner, appellant, rebuttal.
Your Honors, opposing counsel just pointed out the very problem in this policy. By going with what their argument is, such programs such as the voucher programs, public goods, could not be given to churches because of the worry that money saved by the churches not providing this by themselves.
You agree with their argument, though, that religion as a category is not a powerless group, correct?
The very fact, Your Honor, that REFRA and RILUPA had to be made in the 90s shows that religion has been threatened in the past.
But that wasn't my question. The question was whether there's power to act within the political process. And if there is, then isn't this something that the political process should take care of through democracy and not an unelected court?
Well, the other part, Your Honor, of the strict scrutiny application is that when a law is facially prohibited by a part of the Constitution, that also triggers the strict scrutiny. So just because a class of people may have political power or not, if a law is created that on its face violates a fundamental right of the Constitution, that triggers the strict scrutiny standard, as applied by the Caroline Products footnote.
But if we do that here, right, it doesn't trigger it because we don't have a free exercise or an Establishment Clause problem, so we have no fundamental right implicated. And their argument is if putting aside fundamental right, you don't have suspect classes because you're dealing with a group of people that are politically powerful and can act through the political process. So I understand you're saying yes if there's a fundamental right violation, but that assumes your co-counsel wins on the free exercise clause. If you don't, and we're only on equal protection, I'd be interested in what your argument is for why we create a suspect classification on a group that doesn't meet the Caroline Products definition because they have political power in the system.
But again, this goes back to previous case law that says drawing lines upon inherent suspect classes triggers strict scrutiny. Again, this, seeing as my time has expired.
Go ahead and finish your thought.
With this being an, again, inherently drawn line based on religion, all religion compared to not religion. That is an inherently suspect class. Again, getting into the political powerlessness, what have you, but again, this is a suspect class as defined by previous case law passed by this court. And with that, Your Honors, we humbly request that you reverse the lower court's decision. Thank you.
Thank you, gentlemen. The court will now recess for consideration. Please be seated. I invariably come into the courtroom and say, please be seated, good afternoon, then realize it's morning and somebody will roll their eyes, but so good evening, I guess is what we'll say tonight. The way it's been explained to us is we get an opportunity now to make some comments about each of the advocates, but I'm sure all of the judges are unanimous in the view that you all did a marvelous job, and I think we should recognize them for that.
Yeah.
So, Judge, why don't you start off and give us a few thoughts?
I echo what Judge Carr said. You guys were outstanding to get up here and do this. To everyone who participates, it's just an incredible program that you have going here, and hopefully it'll keep up, and you guys will be contributors in the future, sitting up here where we are. Jacob, I'll just run in order. Jacob, very strong, good eye contact, very confident demeanor, a pleasure to listen to. And I speak, as for all of you, we did not get into the case law with you like we did some of the other people, is my recollection. I tried to throw a softball on Widmar, kind of rolled through that and got out of it real quick, and I thought Widmar might be something you run with. Try to distinguish those softballs when you can and run with them. Good job on rebounding to a lot of the questions. Benjamin, very strong. You have a strong voice, a strong presentation, very impressive demeanor about yourself. That will serve you very well. Your ability to interact with this panel was very impressive. I can leave it at that, and the others will comment further. Walker, I don't know that anyone up there knows the case law as well as you and your ability to move from case to case, although Colin Bell is pretty close. You guys were able to discuss case law, which impresses, I think, the judges on the panel. I'm a trial court judge. It doesn't matter to me as much as it does them when you get into the weeds there, but very, very strong in the case law. Did notice a lot of hand movement, which behind the podium, not as noticeable, but once in a while it came flourishing up. Maybe not a liability all the time. Sometimes it's a strength if utilized properly. Colin Bell, overall strong. The dean here just threw some wicked hypotheticals your way, and you were able to handle. He threw them at Mr. Wade too. He got rolling, but Mr. Bell, you handled them. You got into the weeds a little trying to argue the strict scrutiny, tough argument to make. You went there, so he rode that horse as far as he could into that weed patch, and you were able to parry him quite well. So kudos to you, job well done, sir.
Dean?
The dean.
Yeah, no. Look, just to echo, I thought this was an exceptional performance. I thought you all four did a really nice job, certainly on the level of some law students that you see, and maybe higher than some lawyers that you see. My own bias there.
Yeah, I think so.
I'll do the same thing, just go down the line. Jacob, what I was particularly impressed with is I think it's critical in appellate oral arguments to answer the judge's questions directly and then move on to the explanation. And I thought you did a really nice job of answering in a short snippet, punchline answer, and then moving on. And I felt there was a number of times where we asked a difficult question and you gave us that main key answer so that we felt satisfied before you went on to the explanation. I thought that was great. I think you didn't sense our discomfort with the way that you were describing the direct and indirect sort of funding, and I thought you could have been more sensitive to the nervousness of the bench there about how you're using that to distinguish the cases and come back a little stronger. But I thought forensically, I thought you did a very nice job, and it was a great performance. Ben, also very strong, nice composer, really thought you responded well to questions. I thought you needed a clearer understanding yourself as you were going in whether you're going to concede locked or not. And you eventually got to the position that you thought it should be overturned. I think if you're going to get there, you need to go in with it. And if you're not, then I think you need to stick to your guns that locked does not need to be overturned. I felt we had you a little more on the rails than you needed to be there. But I thought it was a really strong job, and we were pushing you hard, and I thought that was great. Again, your command of the materials was wonderful. Walker, I really liked your signposts. I thought having a nice, clear signpost at the start of the oral argument is key, and I thought you did that nicely. I also noticed that your hands might have been more flamboyant than you'd want. I think it's less important in my mind for real court, but incredibly important if you want to go on for law school competitions that you sort of meet the custom. And so that's something you might want to work on. I also wrote that I thought you had exceptionally good knowledge of the details and the facts of the cases, and I thought that was really impressive, and so I liked that. I have a note that you made a nice concession at one point where I thought you needed to make that. Colin, great eye contact. I thought you kept good eye contact all the way through, and I thought you had a great way of responding to a fairly hot bench. I was pushing you on sometimes, and I thought you did well. On the substance, I thought you did a very nice job of getting to where you needed to be on suspect classifications. I would have liked to have seen you move me there quicker, but I thought you had the answer, and I thought you did a really good job of shoring that up on the difference between the suspect classification and the fundamental right. I had very good knowledge of the facts too, and I was impressed. So all in all, I just thought it was a superb job, and I felt privileged to be part of it. I was having a great time up there, and if I'm having a good time, I consider it a good oral argument. So thank you very much for that.
Professor?
First of all, I thought everybody was terrific. This is really a good argument. Jacob, I thought you got us off to a great start. I thought you were getting a lot of tough questions, and you just hung in there and answered them, and you didn't get rattled, and it was terrific. And Ben, you obviously know this stuff. You're tenacious. You really go after it, and I was very impressed. Walker, you are very good not just for a sophomore, you're just very good. And I thought you did a great job. And Colin, you're cool and steady, and you don't get rattled. And I was very impressed with the way that you handled the questions, because you were getting some tough ones.
Well, I finally figured out in my mind, but literally 1 week ago tonight, I was down in Bloomington judging moot court competition at the law school. Those are, by and large, I think maybe all 2Ls. They're all second year. And it was admittedly not the final round, but you were better than all of them. I heard 3 arguments that night. All 4 of you were better than the 6 law students I heard last Tuesday night. I'm not, blowing smoke at you. It's the truth. You were. And I know that this bench was hotter than any bench I've seen for the law students. Everybody here was primed and ready to go because, you know, we only had one argument tonight. And so everybody was firing their guns, and you had 4 judges when generally it's a 3-judge panel in the moot court competition. So you ought to look forward to the law school moot court competitions. I'm sure you're all going to be in and you're all going to do well in. I'm going to make my comment short because I get the great honor of then passing out these awards. Jacob, we pounced right on you, and I was very impressed. A lesser advocate would have wilted against the barrage of questions that you were met with. You didn't get a chance to get more than a couple of prepared words out of your mouth before we just launched an onslaught on you, and so I give you high marks for that. Benjamin, it's clear you're very experienced at doing this. I think you told me you won this competition last year, and I can see why. Walker, very good. Once again, not just for a sophomore, tremendous job for any competitor, and you did have probably one of the best commands of the case law. Colin, excellent job. You had tremendous eye contact. You had a tremendous response to questions. You came up with some very great arguments when you moved to the argument about the political power of religious groups in general. That was, for the first time, you caused the panel to sit back and listen instead of peppering you with questions, so you did a tremendous job there. So once again, great job by all of you. And I'm not rushing this forward just because I want to go find out if the Cubs are going to win the first game of the World Series. Although it is a factor, I won't lie to you. And for those of you who haven't been able to check, they're down 1-0. So they're down 2-0 now. Might as well stay here. There's probably a dramatic way to do this, but I'm going to opt for the less dramatic way. It wasn't easy. It took us a lot of thought and consideration, but the panel of judges has decided that the award for the Wabash College 2016 Moot Court Top Advocate goes to Colin Bell.